So, how do you solve a problem like special category data? Another question we could actually ask is the current approach to SCD actually working? Because what we've seen over the last few years is the CJEU and the DPAs taking an ever more expansive interpretation of what information is special category data and will fall within Article 9. And in some cases, the court has also taken a more restrictive interpretation of the available Article 9 conditions. This trend has continued over the last year, and my article in the top 10 publication looks at 2 cases from the CJEU which examine this issue. But for the purposes of this presentation, I thought it'd be worth reflecting more generally on where things currently stand on SCD, the challenges posed, and then also consider whether there are any answers at this stage. As everyone here will of course be aware, in order to process information that's SCD, you need to establish a condition, also referred to as an exception, under Article 9.2. If you can't establish a condition, you cannot process SCD. Now, establishing an Article 9 condition has always been something of a challenge. Of course, many of you will be aware of this, and this isn't new. However, what's developed a bit more over the last few years is a tricky combination of the courts and the DPAs taking a broader interpretation of SCD. Therefore, a greater volume of personal data is falling within the scope of Article 9 and requiring an Article 9 condition. And at the same time, we're seeing a development of new technologies, in particular generative AI, which of course involves processing large data sets, which may well incidentally include SCD. I thought it'd be useful to highlight very quickly just a few of the recent CJEU decisions, because they illustrate how broad the scope has become. So the particularly significant and also particularly unhelpful in some ways case of OT saw the CJEU hold that the name of an individual's spouse, cohabitee or partner could indirectly reveal information about that individual's sex life or sexual orientation. So essentially the court was saying an inference from relating to someone's sexuality can be drawn from non-sensitive, relatively commonplace data. And in the Linden Apotek case, again, the court looked at this issue of inferences and said that a certain degree of probability is sufficient for an inference relating to someone's health to be SCD, because in this case, there was a pharmacy that was selling medicines online and they didn't need a prescription from the individual. So they couldn't confirm that the purchaser was definitely going to take that medication. And yet the CJEU said, no, that's information concerning that individual's health based on this idea of a certain degree of probability. And then finally, I think it's also worth mentioning that in the Meta Bundes Carte-Melamp decision, the CJEU said it's irrelevant if the SCD is correct or if the controller intended to collect the SCD for the purposes of trying to work out whether Article 9 applies or not. So what's the upshot of all of this? Well, it means that previously controllers were always quite clear when they were processing SCD, whereas now the situation is quite a lot more complicated. Now, obviously, we're in the UK, and post-Brexit, the CJEU decisions aren't binding. Now, the ICO has taken a slightly more nuanced approach in relation to these inferences relating to SCD. And they've said in their guidance, which was updated last year, that an inference will only be SCD if the controller intends to make an inference linked to one of the special categories of data, or if they intend to treat someone differently based on the inferred information linked to one of these special categories of data. So there's slightly more flexibility and a bit more nuance there. The challenges related to SCD can really be illustrated when we look at training generative AI models, because obviously training LLMs requires a huge data set, often comprised of publicly available information from the internet. And again, this information may well incidentally contain SCD, particularly if you're taking a broad interpretation of the concept. Now, it can be very difficult to find an Article 9 condition in this context. While the manifestly made public by the data subject condition may be available in some cases, this won't be the case in all instances, particularly if you consider the information might have been made public by somebody else. And another challenge, another issue that arises in this context is also if you're trying to reduce bias in your AI system. So if you have an AI model that generates images of people, you want to make sure that it can generate images of people that are representative of society as a whole. But in order to do that, you may well need to process information that would be considered SCD. And yet finding an Article 9 condition, again, can be very difficult in this context. So, to continue the Sound of Music theme, and back to our favourite slide of the evening, how do you solve a problem like special category data? Unfortunately, at this stage, there are no easy answers. And what we're seeing controllers do is think creatively about the available legal arguments and Article 9 conditions, because depending on the context, you might be able to look to other conditions, such as substantial public interest or even research, depending on the context, and see if those could apply. For training LLMs, there is some case law that's slightly more helpful. For instance, the GC v. Keneal CJEU case, which involved Google, in which the court held that if you link to web pages that contain sensitive data, you only have to treat that information as sensitive data when you've received an erasure request and effectively been put on notice about it. So I think ultimately this SCD regime was intended to protect information that is sensitive. Of course it was. However, the broad interpretation of Article 9 from the courts and DPAs often seems slightly at odds with a society and culture that arguably is increasingly open about information that would be considered SCD. And obviously more of our lives are lived online and more information is shared in this way. And actually, you might question whether isn't context often key to determining what is sensitive and crucial for determining how someone feels about information and how it is being used. The current legislative regime doesn't really allow for context to be taken into account when making this assessment. And so at this stage, it's a case of waiting to see how the courts and the DPAs continue to grapple with the SCD challenge over the coming years. I'll hand over to my colleague, Faye, now.